parole for this in the state of Florida. Before you may vote that the court impose a sentence of death, the state must prove one or more aggravating factors beyond a reasonable doubt. Once all the evidence in the penalty phase has concluded, you will retire to the jury room with a set of jury instructions from me giving you the law at this stage of the proceedings. You're going back into that jury room with your fellow jurors to undergo the process of making the decision. It involves weighing aggravating factors and mitigating circumstances to determine the proper punishment. This process is not a mechanical or mathematical process. And by that I mean you don't go back there and add things up and say, well, there's this many aggravators and this many mitigators. That's not how it works. The law contemplates that different factors, different mitigators or aggravators, may be given different weight or values by different jurors. In your decision-making process, you and you alone are to decide what weight is to be given to a particular factor. Your decisions at this stage of the proceedings are individual. Each juror may give individual weight as they see fit to each aggravator and mitigator. Regardless of your findings in this respect, however, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. In other words, your verdict for death must be unanimous. Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If, after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. That's a very broad outline of the penalty phase. We'll be explaining things to you a little bit further during individual questioning as needed. Let me also caution you about one thing. The fact that I'm talking about the death penalty is not to be taken by you as an indication one way or another as to whether or not this is a case which justifies a death penalty. I don't know that, and you don't know that. I'm only discussing this because it's a possibility. It doesn't presuppose anything. We just have to be ready in case it happens to make sure that you would be able to do your job as jurors if you were in a penalty phase. We're going to be asking you some questions about the death penalty. I'm going to tell you what some of them are just so you can think about them a little bit, because these aren't questions that you normally face. We're going to ask you if you have a moral or religious objection to the death penalty. You're going to be asked if you're someone who believes that death should be automatically imposed for certain types of cases. For example, in a first-degree premeditated murder. I'm going to tell you right now and instruct you that there is no automatic death penalty in the state of Florida, including for first-degree premeditated murder. We're going to ask you if you can weigh aggravators and mitigators and listen to the evidence in the penalty phase with an open mind, go through the weighing process, and vote for either life or death, whichever one you believe would be the appropriate sentence. We're also going to ask you if you are a person who is so opposed to the death penalty that you simply can't impose it no matter what the law or the circumstances are. People have very strong feelings about the death penalty, both for and against it. The fact that you may have such feelings does not disqualify you as a juror, so long as you can set those aside and follow the law as I instruct you. In other words, you have to be willing to be bound by your oath as a juror to obey the laws of the state of Florida. Moving on, Mr. Loyd has raised the insanity defense in this case. I'm going to read you the definition. And I'm also going to tell you that this is the only time, this would occur in the guilt phase, when you're the first phase of the trial, when you're trying to decide guilty or not guilty. This is the only time that the burden is on the defense to prove this, not the state. The burden is on the defense to prove insanity, and it's by clear and convincing evidence. I'm just going to tell you what in the instructions the definition is. We will have some questions for you about this defense. A person is considered to be insane when he had a mental infirmity, disease, or defect. Because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. The instruction's a little bit longer, but that's enough for today's purpose. We will be asking you about your feelings about that defense. In other words, can you listen with an open mind, and if it's proven, could you vote not guilty by reason of insanity? And lastly, I'm going to read you a statement about this case. It's a little bit about the facts. It's a very little bit about the facts of the case. On the morning of January 9th, 2017, defendant Markeith Loyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Loyd had an active warrant for his arrest. Orlando Police Lieutenant Debra Clayton attempted to take Mr. Loyd into custody on the information she received regarding Mr. Loyd's involvement in the Dixon homicide, when it is alleged Mr. Loyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Loyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and ended and concluded on October 23, 2019. Mr. Loyd was convicted and sentenced to life without the possibility of parole. Those facts about Ms. Dixon and her unborn child and that conviction and the life sentence may not be used by you as evidence of guilt in this case. It is being offered for a different purpose, and you would receive specific instructions from the court as to what to do with that testimony. But we are going to be asking you questions about whether you can put those facts aside in determining guilt on these charges that he's facing now. All right? So let me ask you some quick questions by show of holding up your paddles only, please. How many of you have heard about this case prior to today? All right, so I have, once I call your number, you can put it down. 22, 34, 36, 46. Are you holding up your paddle? 50, 52, 53, 55, 58, and 60. All right, of those of you who've heard about the case, how many of you have formed an opinion about Mr. Loyd's guilt or innocence? Anybody? Nope? Okay, thank you very much, folks. So, I'm going to start with your juror number 14, right? All right, if you'll stay in the courtroom, the rest of you go into the jury room. We'll be with you just as soon as we can. All right, ma'am, you're juror number 950, right?
Yes.
Can you hear me through this mask?
Yes.
Okay. And you haven't heard anything about this case, correct?
No.
Okay. I'm going to be asking you some questions, and the attorneys will have a chance to ask you questions, okay? There aren't any right or wrong answers to this. You're not getting graded. All we're looking for is for you to be honest with us. You understand?
Yes.
So just answer the question, and don't worry about what your answer is, okay? You haven't heard anything about this case, correct?
No.
You haven't talked to anybody about it? You don't know anything about it other than what I've just told you?
No.
All right. Do you have any religious or moral objections to the death penalty?
No.
Are you someone who believes that if someone is convicted of first-degree premeditated murder, the intentional murder of another person, they should automatically be sentenced to death?
No.
Okay. In the state of Florida, there is no automatic penalty there's no automatic death sentence for intentional first-degree murder. You understand that?
Yes.
You heard me describe what the process is of trying to decide whether you want to vote life or death. Let's say you've listened to all the evidence, you've listened to the state's aggravators, the defense's mitigators, the things the state believes are the reason you should sentence someone to death. The mitigators are the reasons the defense believes you should sentence someone to life. You're going to go back in that jury room. You can discuss it with your fellow jurors. You're going to weigh the aggravators and the mitigators, think about all the evidence, everything that you've heard throughout the trial. If at the end of that process, you believed that the appropriate sentence was life without the possibility of parole, could you vote for that?
Yes.
If at the end of that process you believed the appropriate sentence was death, could you vote for that?
Probably.
Probably? Okay. Why is the answer different? You said yes to life and probably to death. What's concerning you?
Just that I would have to sentence someone to death.
You are really soft-spoken. Can you speak up a little bit?
Just that I would have to sentence someone to death.
Okay, you would have to vote for the court to impose a sentence of death?
Yes.
Okay. So it's the responsibility of it that's weighing on you?
Yes.
It's a scary thought when you first hear it. I understand that. It's a huge responsibility to decide to vote life or death. So the question is, as you sit there, just think about it for a minute. Could you do it if you thought that was the right sentence?
I believe I could do it if it was right.
Now, remember what I told you, you're never required to vote for death, but you have to be open to it, and if you believed that was the appropriate sentence, be open to voting for death, but you're not required to do it. You understand that?
Yes.
Okay. The insanity defense. If at the end of the guilt phase, when you're trying to decide whether he's guilty or not, you felt the defense had proven to you that Mr. Loyd was not guilty by reason of insanity, could you return that verdict?
Yes.
All right. And can you follow my directions about not using the Sade Dixon murder conviction and that of her unborn child and the life sentence as a basis or anything to decide whether he's guilty or not of these charges? Can you put that aside?
Yes.
All right. Thank you, ma'am. I'm going to turn this over to the lawyers. Mr. Buxman, you may inquire.
Thank you, Your Honor. Good afternoon, ma'am.
Hi.
A few minutes ago, the judge and you were talking about if you felt the proper punishment in this case was death. You said, I think I could vote that way, or I probably could, or I think. You were a little hesitant. Now, a judge friend of mine uses an example of if you're going to go and get in a plane to go, you're going to have a trip to New York, you're going to get in a plane, and you get in there, and the pilot's greeting you when you walk on the plane, and you say, Mr. Pilot, we're going to have a good flight, we're going to land safely, and he goes, I think so. Would that instill a lot of confidence in you as a passenger on that plane that he thinks he could land the plane?
Not really.
Okay. See where I'm coming from? I'm going to talk about a few other things, but kind of put in the back of your mind, think down into your heart and your soul. It's a daunting task, and this is a heavy situation, especially for someone, I believe you're 18, right? This is a heavy task for people twice as old as you. So I'm going to put that on hold and go through a few other things. We're going to come back to that, okay? The judge, you indicated to the judge, and she told you that there's 2 stages to this trial. And the first stage is called the guilt phase. Now, in that phase, your job as a juror would be to determine if the defendant is guilty or not guilty of the crimes charged. If the jury unanimously finds the defendant guilty of first-degree murder, then only then would we move to the second phase of the trial, which is called the penalty phase. That make sense?
Yes.
Okay, and I'm not trying to talk down to you. There's a lot of information we just threw at you. I'm just trying to walk through it step by step, okay? No matter how bad the murder was, how egregious it was, how premeditated it was, if there wasn't any defenses, that doesn't matter in the penalty phase. What matters in the penalty phase is what is the proper punishment for this case, okay? Now, you're going to be able to, if we get to that point, you'll be able to consider the facts of the homicide, but there is no such thing as an automatic death sentence, no matter how bad the murder is. Does that make sense?
Yes.
The system says that a defendant convicted of first-degree murder is entitled to a jury that can listen to additional evidence to see if this specific case warrants the death penalty. Okay, so would you be able to follow the law that just because someone is convicted of first-degree premeditated murder, that person still is entitled to a jury to listen to additional facts before making the ultimate sentence?
Yes.
Does that make sense?
Yes.
Okay. If we get to the point where we're talking about a sentence in this case and the jury's asked to decide the sentence in this case, the state will introduce evidence that are called aggravating factors, which are factors that make this murder more egregious than other murders. No matter how many aggravating factors are shown to you, no matter how horrible those aggravating factors may be in your mind, would you still be able to listen to the mitigating factors presented to you by the defense?
Yes.
Okay. So can you hold off your judgment until you hear the other side of the story, the mitigating evidence, the evidence that suggests that life may be the proper punishment in this case?
Yes.
Okay. Do you think that Mr. Loyd would be entitled to have a jury who would hold off judgment and listen to all of the evidence before you form an opinion?
Yes.
This isn't the time to talk about the details and the evidence that you'll hear about each of the aggravating factors or each of the mitigating circumstances. That's during the trial, because we can't talk about the actual evidence in this case. But can you promise me that you would be able to listen to all the evidence before you come to a decision? So if I stood up here and asked you about 100 different mitigating factors, am I correct that your answer would be, I would listen to that evidence, I would consider that evidence, and then only after I hear it all would I make a decision?
Yes.
Now, once you hear the evidence dealing with an aggravating factor and a mitigating circumstances, you can then decide to do a few things with that information. You can find that the evidence didn't prove that those factors were even applicable. Or you could say, well, the evidence proved that the aggravating or mitigating factors exist, but this factor really isn't important in my decision-making process, so I'm going to give that a little weight, little to no weight. Or you could say, this piece of evidence is really important to my decision-making process as far as what the sentence should be, and give it a lot of weight. That's up to you. Can you go through that process and that analysis before making a final decision in this case?
Yes.
Once you make that analysis, and if you decide that the aggravating factors outweigh the mitigating circumstances, then you'd be authorized to vote for the sentence of death in this case. Does that make sense? That is an individual determination made by you and each of the other jurors. And no matter what, you never are required by law to vote for the death penalty. If all 12 jurors agree that death is the proper punishment in this case, then it has to be unanimous, and then it could become a potential punishment here. Okay, but it would take all 12 people to vote for death in this case. Does that make sense?
Yes.
All right. Now, back to where we started. I'm going to ask you that airplane example with you, and you said, I think I can. If, after going through this whole process, you're back in the jury room, and you consider all the evidence on the aggravating factors, and you think that evidence outweighs the mitigating circumstances such that you think death is the appropriate sentence. And I'm talking in a situation where, a real life situation where you are the one having to make the decision, not you hanging out with your friends, talking to your coworkers, saying, I could vote death in that case, but a real life situation. Looking down into your heart of hearts, into your soul, you know you best. Would you, if you found that the evidence supported the death sentence in this case, and you felt that that was the proper sentence, could you come into this courtroom, raise your hand, and by your vote, say this man deserves to die for what he did?
I'm sorry? The statement of the law as to this juror's role in this case.
Overruled.
You think you could do that?
Yes.
Yes? What were your thoughts about going through that process, what we just talked about, and you answering, yes, you could now, as opposed to before you said, I think I can? Kind of what changed in your mind?
No.
Okay, no, that's fine. Are you nervous?
Yeah.
Okay, don't be nervous. It's just us talking. It's okay, don't be nervous. Was there something in the beginning of this that caused you some hesitation about the responsibility of having to make that decision? Okay. Is there something that, since we've been talking and going through the process, that changed in your mind about your ability to make that ultimate decision?
Yes.
I'm sorry?
Yes.
Okay, what was that?
That's not like guaranteed.
You get us together.
That's not guaranteed.
What do you mean?
Like my vote wouldn't necessarily like guarantee the death penalty. It would just be a possibility. Is that correct?
The law is that the court cannot impose a death sentence without the jury unanimously voting for it. The sentencing of Mr. Loyd is done by me.
Okay.
Now, none of us want you there thinking that because the judge does the ultimate sentence in this case, that your vote is not important. Okay, your vote is very important. It might be one of the most important decisions you'd have to make. So please don't think that it alleviates your responsibility to consider the evidence and make the proper decision in this case simply because the judge makes the decision.
Let me follow up on that.
Thank you, Your Honor.
Mr. Buxman. You have to take this as seriously as you've ever taken anything in your life, okay? Without a unanimous vote from the jury for death, the sentence is life without the possibility of parole. It's an automatic sentence. But when a jury votes for death, that then comes to the judge, and it comes to the judge with a presumption that you have to respect, that the jury has said death is the appropriate sentence in this. All I'm trying to tell you is ultimately you're not pronouncing sentence on Mr. Loyd. I'm pronouncing sentence on Mr. Loyd, okay? But your vote is your vote, all right? And I can't sentence him to death unless I get 12 jurors saying, I'm voting for death. You understand?
Yes.
All right, so Mr. Buxman is right. I don't want you to think that this isn't serious because you're not the person who has to say anything, okay?
Yeah, I understand.
All right.
knowing that your vote is incredibly important, and we can't be thinking that someone may bail you out or something like that if you vote death and somebody else could take that responsibility away from you. That responsibility lies on you and your 11 other jurors. Knowing that the weight of that responsibility, would you still be able to go back in that jury room, deliberate, and if you felt the sentence was appropriate for death penalty in this case, would you be able to come in here, raise your hand, and say the death penalty should be imposed on another human being?
Yes.
Okay. As far as the insanity issue that the judge mentioned earlier, one of the components of the insanity defense is a mental health, mental illness. I'm going to ask a couple personal questions, and I apologize, but is there any, do you have either you, a close friend, or family, any experience, significant experience with a mental illness?
No.
No, okay. Do you feel that mental illness is a legitimate part of society and legitimately affects certain people?
Yes.
Okay. Would you be able to listen to all the evidence regarding whether a mental illness exists in this case, and if so, what the effect of that mental illness is before coming to a conclusion as to whether insanity has been proven?
Yes.
You could do that, okay. Is there anything in your life, your background, that may, in your mind, make you feel uncomfortable and make you feel you're not a good juror for this type of a case?
I'm 18 and I'm a college student. I guess that's it.
Okay. You're in college right now?
Yes.
Okay, are you taking, we may have gone through this, and forgive me if I don't remember, but do you take online classes or in person?
They're all online.
They're all online? Can you do those online classes anytime, or are there specific times you have to be present online?
I can do it anytime.
Okay. And being an online student, would you still be able to keep paying attention to this case if you were selected as a juror and not wondering, God, when can I get out of here? I have online classes to do. I'm getting behind.
Yes.
Okay. If I could have one moment, Your Honor?
Sure.
Last question for you, I promise. You mentioned a minute ago, I'm 18. Are you comfortable that you have the life experience to take on this responsibility?
I think so, because I'm 18 and I haven't experienced this before.
Okay. I believe, and forgive me if I couldn't quite hear you. You said, I don't think so.
And I haven't experienced this before.
Okay. Well, not many people have experienced this situation before, but does the fact that you're 18 concern you as being a juror in this case? Why?
Because I'm young.
Okay. Okay. Do you think that would interfere, just you being young, being 18, would make it difficult for you to follow the trial, follow the legal concepts involved, anything like that? A little? Okay. In what way? Can you? I told you it was one question, but I apologize. In what way?
I don't know.
Okay. Okay, fair enough. Nothing further, Your Honor. Thank you, ma'am.
Thank you, Mr. Bell.
Who's up? Ms. Miller? You may proceed.
Hi. So Mr. Buxman gave you a lot of law, right? I just want to have a conversation with about your feelings, okay? You are selected as a juror in this case, sworn, and you will take an oath to do something different than the oath you've taken thus far, which is just to tell the truth. And I can promise you, you're going to get it on paper, and the judge is going to give you all the instructions you need, okay, if you're selected. So now this is really the time where we just talk about your feelings on the two possible penalties for first-degree murder: life without the possibility of parole or the death penalty, okay?
Okay.
And I know you're on the spot, but nobody can see you, I promise, other than who's in this courtroom, okay?
Okay.
The answer I think you gave the judge initially was that you could impose death, and your quote was, "I believe I could if it was right." Do you remember saying that?
Yes.
Tell me what you mean by that.
Like, if there was enough evidence to support that they deserved the death penalty.
Okay. And I'm not asking you to tell me what you think is aggravating or mitigating. I'm trying to get a better understanding of what you mean when you say, what evidence to support the death penalty?
I don't really know.
Okay.
Just,
Well, so let's start at the beginning. In order to even get to this second part of the trial, we may not even get there, right? The second part of the trial is only if Mr. Loyd is found guilty of intentional premeditated first-degree murder, okay? So intentional first-degree murder in Florida is the intentional premeditated killing of an innocent victim without legal excuse, justification, or defense, right? That's how we get to the second part, is only if somebody is guilty intentional premeditated killing of an innocent victim without legal excuse, justification, or defense. With me? So how do you feel that somebody who's guilty of the intentional premeditated killing of an innocent victim should be punished?
I guess with life.
Say again, I'm sorry?
I guess with life and without parole.
Okay. That is right. That's instinctively right where you start. And then the state would have to prove the existence of an aggravating factor before somebody's even eligible for the death penalty. Okay? So if somebody's guilty, and we're in the second part of this, right, the state has to prove the existence of at least one aggravating factor before you can even consider death as a possible penalty. Okay?
Yeah.
And that's what the law requires for you to serve as a juror in this case, to be able to give meaningful consideration to both possible penalties, life without the possibility of parole or the death penalty. And you can do that, right?
Yes.
Okay. I believe on your questionnaire, you talked about having family and law enforcement, family or friends in law enforcement. Is that correct? Okay. Tell me who of your family or who you know that's in law enforcement, please.
My uncle who lives in Massachusetts.
Okay. Would you say you're close with that uncle?
Yes.
Like, do you talk frequently?
Well, only like if we go on vacation.
So you don't call and chat?
Sometimes.
Okay. The judge told you this case, Mr. Loyd is accused of killing a police officer, Lieutenant Clayton. Do you think you would have trouble finding him not guilty of this crime if the state hadn't proven that he was guilty beyond a reasonable doubt, or if we proved that he was not guilty by reason of insanity because you have a family member who's in law enforcement?
No.
You could conceive of finding Mr. Loyd not guilty and still having those conversations with your uncle who's in law enforcement and being able to say, listen, you know, this is why I did this, or whatever the case may be.
Yeah.
Okay. Again, no right or wrong answer. Some people say, listen, I have a sister who's in law enforcement, and this just isn't the case for me, right? I'm just trying to figure out what your relationship is with your uncle if it's one that would make it difficult for you to sit as a juror in this case. What do you think?
I don't think it would be that difficult.
Okay. So we talked about your feelings on how someone should be punished who's guilty of the intentional premeditated killing of an innocent victim, right? What are your feelings on how someone should be punished if that innocent victim, the intentional premeditated killing of the innocent victim, the victim was a law enforcement officer? Sure. Does the fact that the victim was a law enforcement officer, right? So it's an intentional premeditated killing of an innocent victim, but the innocent victim, for the purpose of this question, is a law enforcement officer. What are your feelings on how that defendant, how he should be punished?
I don't really know, like, how he can be punished.
Okay. Do you think because the victim is a law enforcement officer that makes you think death should automatically be the penalty?
No.
Say again, I'm sorry.
No.
No, okay. This murder, we're talking about what the appropriate penalty is once you found somebody guilty of the intentional premeditated killing of an innocent victim. If that defendant also found guilty of another murder, does death become the automatic penalty for this murder?
Maybe.
You're doing great. Just tell me what you're thinking. What's in your head? Go ahead and say it out loud.
I don't really know.
You don't really know? Well, let me ask you a little bit differently. We're talking about this murder, but knowing that defendant also has been previously convicted of murder and is serving a sentence of life in prison without the possibility of parole. Is life in prison without the possibility of parole a significant penalty under those circumstances?
Yes. Yes. Yes.
Yes. Tell me, if you heard about this defendant who's been found guilty of the intentional premeditated killing of an innocent victim, being exposed to racism throughout the course of his life, would that have any effect on your decision making as to what the appropriate penalty is?
No.
No?
No.
Okay. You had talked to Mr. Buxman about mental illness, and you believe mental illness is a real thing, but you don't know anyone, or you've never met anyone who has a mental illness. Is that fair? Okay. Do you think mental illness, or is mental illness something you could consider or contemplate when deciding whether life or death is the appropriate penalty? Why do you think your responses are different about mental illness and the effects of racism?
Wait, what?
So one, you said that would play some role in your decision making as to what the appropriate penalty is, right? Life or death?
Yes.
Okay. And one, you said it would not. Is that fair?
And that they would play a role.
The effects of racism and mental illness? I'm sorry, I don't understand.
Can I see the attorneys at the bench, please?
Yes, ma'am. Okay, just a couple more things, okay? Oh, I'm sorry. I think we fully hashed this out, but if you are selected to be a juror in this case, the decision and responsibility about whether or not Mr. Loyd lives or dies is unequivocally yours as a juror. You understand that?
Yes.
And that's what I'm not trying to overstate it or understate it, but it is an awesome responsibility. With me?
Yes.
Death is never required, not in any case. It's not automatic. There's no set of circumstances where if you apply the law, as Mr. Buxman discussed with you, that you come to the end of it and you have to vote for death. That is never the case. With me?
Yes.
Not in this case, not in the worst possible case you can imagine. Okay?
Yeah.
Where does the decision to give life come from? We call it mitigation. We've thrown that word about a bunch, and it is literally why any one person would choose life or not choose death. Okay? It can be unique to each individual juror. You could find something mitigating, and every other juror could disagree with you, and that's okay. It doesn't have to be unanimous. Not all of you have to agree on things like mitigation. Okay?
Yes.
The state, when they present aggravating factors or present evidence of aggravating factors, they're limited to one of 16 things set out in the law in Florida. But mitigation can be absolutely anything. It can be even something seemingly insignificant like a smile you observe between the defendant, his mother, or a family member. With me?
Yes.
Okay? And if any one juror decides that life should be the verdict, then life will be the verdict. Okay?
Yes.
And that's what the law contemplates and calls for. In order for a just verdict to be returned, all 12 jurors' individual moral assessments have to be reflected in that verdict. So there's one verdict form, one foreperson who signs the verdict form, but it should be reflective of all 12 individual moral assessments of the folks on that jury. With me?
Yes.
And so it's sometimes a difficult challenge that it is your duty, your right, and your responsibility to make sure your individual moral assessment is heard in this courtroom, right? It would be a miscarriage of justice if somebody were able to bully or badger you into changing what your individual moral assessment is. You know what I mean?
Yes.
And so if you have reached a verdict and it's for life and other jurors aren't respecting that, you can say, we're done here, write that down, we're going home, I'm going to get the deputy to get the judge, we've reached a verdict in this case. With me?
Yes.
Thank you, ma'am.
Either side need to approach?
Yes, Your Honor.
Don't worry, I know to wait for you. All right, let me ask you one final question, and this is a non-painful question, I swear. You are a full-time student. Do you want to be excused from this jury?
Sure.
I'm sorry?
Sure.
Sure? Okay, you're excused. Thank you very much. I'm citing the full-time student statute. She's entitled to be excused. It's 41 something. I forgot the end of it. She's entitled to be excused upon request, so I'm excusing her. All right. Take out your pens and take some notes, folks. Jurors have indicated to the deputies that they have certain issues with serving, so I'm going to call them into the courtroom. I'm going to tell you who they are and what their issue is. Juror number 760 in seat 34 has no one to watch her children for 3 weeks. Juror number 931 in seat 44 is indicating this would be a financial hardship. Juror number 584 in seat 50 is indicating that he is scheduled for a hip replacement on November 15th. Juror number 583 in seat 53 is indicating two things: financial hardship and that there is no babysitter for her 4 children. She's given me some additional information that I'll relay to the attorneys at the bench. And lastly, if it becomes necessary, and lastly, I have juror number 553 in seat 60 who is indicating religious beliefs prohibit him, I think it's a him, from sitting in judgment. It's a he, it's a she, him? It's a him, okay. All right, everybody got the notes? So bring me juror 760 in seat 34, please.
Juror 760, 34.
760. Good afternoon, how are you?
Good, how are you?
I'm well, thank you.
Good.
Ma'am, I have some information indicating that you have a problem with childcare if you're selected as a juror in this case.
I do. My caregiver is my mother, but my father recently got sick yesterday, so she has to watch over him now versus the kids.
Okay, because your mom was your caretaker, so
Correct.
she's no longer available to do that.
Yes, ma'am.
Is there anyone else who could watch your children if you were sequestered as a juror for 3 weeks?
No, ma'am.
And what are the ages of your children?
6 and 11.
Okay. State, do you wish to inquire?
State moves, Your Honor.
Any objections from the defense? Sure, no problem. All right, thank you so much, ma'am, for your willingness to serve. I hope your dad feels better and you're free to go. You're excused.
Thank you.
The juror in seat number 44, juror 931.
Juror 931, 44.
All right, good afternoon, sir.
Good afternoon, Your Honor.
You were supposed to find out if your employer was going to pay you. Did you find that out?
Yes, Your Honor.
And are they going to pay you?
No, Your Honor, they're not going to pay me.
Can you pay your bills if you're here?
No, Your Honor.
All right. Any objections from state?
No, Your Honor.
Any objections from defense? All right, thank you, sir. You're free to go. You're excused.
Thank you, Your Honor.
The juror in seat number 50, juror number 584.
Juror 584.
He can have a seat in the first chair. I don't care.
First chair. First chair. Yeah. Change their mind. We'll switch.
Good afternoon, sir.
Good afternoon.
All right, you're juror number 584, is that correct?
Correct.
And you're having a hip replacement in November?
Yes, ma'am.
How long has it taken you to schedule that?
About 2.5 months.
Okay. Are you in a lot of pain?
Not really, but it's time to replace it.
Okay. If you had to reschedule it, how long would it be before you could do it?
Well, based on what we had here, it's probably another 3 months, and I'm scheduled for retirement in February, so I need to get it done before then.
Okay. Is that for insurance reasons?
Pardon?
Is that for insurance reasons you need to get it
Yes.
done before then? All right, state.
State moves.
All right, thank you, sir. Good luck with your hip replacement. I hope you feel better. You are free to go.
Thank you, ma'am.
All right. This is the juror in seat 53. Let me see the attorneys at the bench, please. Just very quickly, I need to tell you something. right, may I have juror 583, seat 53? Oh, he's wearing them, okay, great, thanks.
Get a seat right there.
Good afternoon, ma'am, how are you?
I'm doing good. Good afternoon. How about yourself?
All right, I understand that you don't have a child care available for if you were sequestered as a juror for 3 weeks, is that correct?
Also, I'm the one that go and pick up my kid. You know, 'cause from the house, I wake up and drop them to the school and bring them back.
Right, so you have nobody who can help you take care of these kids?
No, my mom don't drive. And
All right, how old are your children?
I have one that's 4 years old, one 2, and one 14.
All right, any objections, State?
No, Your Honor.
Any objections, defense? All right, thank you, ma'am.
Yes.
You're excused, we appreciate you coming in.
Thank you so
All right,
much.
thanks.
I could go home now, right?
You're all done, yeah. Juror in seat 60, number 553, please.
Number 553.
See right there.
Good afternoon, sir, how are you?
Good afternoon, Your Honor.
All right. Sir, I've been advised that you have some religious beliefs that make it impossible for you to sit as a juror, is that correct?
Yes, Your Honor.
All right, can you tell me what religion you are, please?
I'm Hindu.
You're Hindu?
Yeah.
All right, sir, I confess that I know a tiny little bit about your religion, but not that much. So can you tell me what it is about this case that your religion, that you can't fulfill your duty as a juror?
I look at this case a lot of times on television. I saw it too much times. I'm not saying that, you know, the person did right things, but for my religion, lifetime in prison is no good for me.
All right, so
That cannot affect me. I'm not fit for this case.
all right, I understand that. You don't have to apologize for your religious beliefs, sir, I assure you. We're just going to discuss them a little bit. So the automatic sentence for first-degree murder is life without the possibility of parole. So let me start with the guilt phase. If you found Mr. Loyd guilty of first-degree murder, the least sentence he could get under the law is life without the possibility of parole. So would your religious beliefs prohibit you from participating in finding him guilty or not guilty?
I don't know what I'm going to find him, because that's what I'm telling you. I'm not fit. I don't want to be a juror and then give the other one some problem.
Okay, so let's say he had been convicted of the first-degree murder, and now you have to decide between life without possibility of parole or the death penalty. Do your religious beliefs prohibit you
No death
from
penalty.
imposing let me finish the question, from voting for a death sentence?
No, ma'am. No,
you
Your Honor,
can't.
no.
You can't do that.
No.
Okay. State.
State moves, Your Honor.
Defense. All right. All right. Thank you, sir. Thank you for coming in. You're free to go.
You're welcome, Your Honor.
All right. So, the juror in seat number 15, please. Juror number 720.
Number 720. See how?
Get right here. Thank you.
Good afternoon, sir. How are you?
Fine.
Okay. We have some questions for you. As I indicated, there aren't any right or wrong answers to this. Right? There's just what you actually think and feel. We're not looking for a specific answer. If you could just tell us the truth, you'll be fine, all right? So let me start with, have you ever heard anything or seen anything or read anything about this case?
No.
You got to answer out loud.
No.
No? Okay. So as you sit here today, can you presume that Mr. Loyd is innocent until and if the state proves he's guilty beyond a reasonable doubt? You need me to repeat that?
Yes.
Okay. The law says that all defendants are presumed to be innocent until and if the state can prove they're guilty beyond a reasonable doubt. As you sit here today, can you presume Mr. Loyd is innocent?
No.
You cannot?
No.
Can you tell me why not?
I don't know. I just don't know.
You don't know, you just think he's guilty?
I think so.
Is it because he's sitting in a courtroom charged with a bunch of things that you think he wouldn't be here if he wasn't guilty or if he hadn't done something?
I think so.
Okay. Do you think you could put that aside, or would you start the trial thinking, yeah, I think he's guilty, but let me see if he can prove to me he isn't?
I'm not sure.
You're not sure? Okay. So let me give you 3 scenarios, and you tell me which one applies to you, all right? It's day 1 of the trial. You're a juror. You're sitting in the chair. You're quietly thinking, you know, the judge told me to presume he's innocent, so I'm going to do that, and I'm going to see if the state can prove he's guilty. Number 2, you're sitting in the chair, quietly thinking, okay, I think he probably did this because he got charged with it, but I'm willing to listen and see if I'm wrong. And scenario number 3 is, I really think this guy's guilty, but I'll sit here because the judge told me to. Do any of those 3 apply to you?
Yes.
Which one?
The first one.
The first one?
Yeah.
You can presume he's innocent and you'll wait to see if the state can prove he's guilty?
Yeah.
Okay. So, do you have any religious or moral objections to the death penalty?
Yes, Your Honor. I don't believe.
You don't believe in the death penalty?
No.
All right. Is that based on a religious belief or
Religious,
just your
yes.
personal belief?
My personal belief.
Your personal belief. How long have you had that belief?
I think since I was a kid.
Since you were a child?
Yeah.
Okay. So, because of that belief, would you ever be able to impose a sentence of death on someone? Or to vote, excuse me, let me rephrase that. Would you ever be able to vote for a sentence of death on someone?
I mean, I should be, to me, I should, I should vote or do anything to kill someone.
All right. So you remember the process I described to you. You listen to all the evidence. You go back in the jury room. You weigh the aggravators and the mitigators. If you did all of that, and in that weighing process, would you ever consider a death sentence?
No.
All right. State.
Same to Your Honor.
You may. Yes, ma'am. All right, Ms. Miller's going to ask you a few questions, sir. All right? Thanks.
Hello. Let's start where you left off, talking about the death penalty or life without the possibility of parole. In order to serve as a juror on this case, a juror is required to give meaningful consideration or be able to give meaningful consideration to both possible penalties, the life penalty and the death penalty. Okay?
Mm-hmm.
No one is signing you up to have to give a death verdict. Death is never required, not in any case. But you do have to be able to give consideration to both penalties to be able to serve. Do you think you could give consideration to both penalties?
Not death penalty.
I'm sorry, I can't hear you.
Not death penalty. I don't like that. I don't like to be.
You couldn't even consider it as a
No.
possible penalty? Okay. I have just a moment.
Yes, ma'am.
I have no objection to the state's
All right,
motion.
thank you. All right, sir, this is not the case for you, but we appreciate your honesty, so you're free to go. Thank you.
Thank you.
Juror in seat 22. This is juror number 905. Welcome back.
Thank you.
How are you?
Doing good.
All right. So we're going to be asking you some questions. As I said, there are no right or wrong answers to these questions. There's just what you honestly think and believe. So just answer the question honestly, all right?
All right.
Last time you were here, you told me some issues about your daughter and Halloween, which had us all feeling badly. You said you were willing to serve. Is that still?
It is, and I've actually discussed it with my daughter already.
Okay.
We didn't go into detail, but I explained the process to her, and being 5, she understood to some extent. For being 5, we've had a lot of discussions overall of politics and justice and right and wrong. So this was just another add-on to all of that. So she understood.
Okay. She's a good child. So let me start with this. Have you heard anything about this case?
Yes and no. I was actually working right down the road at Massey Cadillac when all this transpired that morning.
Okay.
So what I heard about it was there was a shooting at the Walmart. Of course, it was on media news. I'm going to be honest, 4 years ago seems like such a long time ago. I haven't heard anything new except for Friday morning when I was telling coworkers, oh, I got to do jury duty today. I guess a little snippet had come on the news channel that they were watching, and they'd brought up this case and then another case in Texas. And we actually discussed the other case in Texas because I had no clue. I don't watch the news anymore. So.
Okay. Based on what you've heard, the snippets, any conversations you may have had with someone, have you formed an opinion as to whether or not Mr. Loyd is guilty?
No, ma'am.
Okay. Could you sit here and presume him to be innocent until and if the state proves he's guilty beyond a reasonable doubt?
Yes, ma'am.
Okay. The death penalty. Do you have any religious or moral objections to the death penalty?
No, ma'am.
On the flip side, are you someone who believes that if someone is convicted of first-degree premeditated murder, which is intentional murder, do you believe that that person should automatically be sentenced to death?
No, ma'am.
Okay. The state of Florida does not have an automatic death penalty for anyone or for any type of case. You understand that?
Yes, ma'am.
I described the process to you. State, aggravators, defense, mitigators, they present evidence. I give you the law, you go back in the jury room. It's an individual decision. You're going to weigh out those aggravators and mitigators. You can accept them, reject them. It's totally up to you individually. Whether you accept them, what weight you give them, you may find some are very important to you, some are not. But at the end of that whole process, you've heard the whole case, you've weighed the aggravators and the mitigators. You believe that the appropriate sentence is life without the possibility of parole. In this case, could you vote for that?
Yes, ma'am, if I believe that was a just verdict sentence, I guess.
Okay. And if your conclusion was that the appropriate sentence is death, could you vote for that?
Yes, ma'am, I could.
Is the fact that count 1 involves the death of a law enforcement officer, would that lead you to automatically vote for death?
No, ma'am.
All right. The insanity defense that's been raised here, it's in the guilt phase. It's when you're trying to decide whether or not Mr. Loyd is guilty, all right? It's the only time in the guilt phase that the defense has a burden. They have to prove it by clear and convincing evidence. If at the end of the guilt phase, you've heard all the state's evidence, you've heard all the defense's evidence, you believe that the defense has proven that he was insane at the time of the offense, would you be able to return a verdict of not guilty by reason of insanity?
Yes, ma'am.
And lastly, you heard me tell you that he's been previously convicted of the murder of Miss Dixon and her unborn child. She was pregnant at the time, and received a life sentence without parole for that case. You can't use that to decide whether or not he's guilty. It's a different case. It doesn't have anything to do with whether he's guilty or not in this one. You understand that?
Yes, ma'am.
Can you set that aside until I tell you now you can consider it?
Absolutely, ma'am.
All right, thank you, sir. I don't have any other questions for you, but the attorneys do. Mr. Buxman, you may proceed.
Thank you. Good afternoon, sir.
How you doing?
Not too bad, you?
I'm here.
I have a couple questions off of your jury questionnaire that you filled out. Have you indicated you had been a juror in the past?
I have.
Okay, was that here in Orange County?
It was.
About how long ago?
Oh, man. 15 years ago, maybe?
You remember if it was a civil or a criminal case?
It was a criminal case.
And without telling me the verdict, were you able to deliberate and reach a verdict?
No, we were not. I don't know what the saying was, but we were, I guess, a hung jury. We couldn't come to a group decision in the back.
Okay.
And
did you come to the decision of whether or not who would be the foreperson?
Yeah, we had nominated someone, yes, sir.
Okay, were you that foreperson?
No, sir.
Got it. Is there anything about your past jury experience that just makes you not want to do this again?
No, sir.
Would you consider it a good experience, a pleasant experience?
It was fair. I mean, it's. I think I've said this before. It's my civic duty. So, you know, to be a part of this nation that we have, and I explain this to my daughter. This is part of what we have to do, and we need to be fair when we're doing this, so everybody can have a fair shot. So, I wouldn't say I was elated, but I'm not, you know, depressed about it either. It's just middle of the road.
Understood. You also indicated that either a member of your family, you or a member of your family has either been accused of, a complainant, or a witness in a criminal case?
Oh, yeah.
Can you tell me a little bit about that?
My siblings.
Okay. What about
them? I actually have one in Seminole County right now without bail. Oh, boy. I think another one's got a warrant out. I'm going to use the term and excuse this, but my family is white trash. I am not. So that'll just draw the line right there.
Okay. Would your siblings' criminal issues affect your decision in this case in any way?
No, sir. I think that they deserve what they're going to get. So
understood.
Yeah.
All right. I'm going to ask you a few questions about the death penalty and your feelings about it and the process that we go through in this. Now, obviously, the death penalty never becomes an issue unless the defendant is found guilty of first-degree murder.
Yes.
Okay, and regardless of how bad the facts of the murder are, how egregious the murder is, how premeditated it was, what defenses were rejected by the jury to get to that point in finding him guilty, he is still entitled to a second phase of the proceeding where a jury listens to aggravating factors and mitigating circumstances. Okay?
Okay.
You agree with that?
Yes, sir.
All right. Do you think that that is a good procedure, that a person is entitled to have that additional procedure following a conviction?
Absolutely, sir.
In that penalty phase, the state would introduce evidence of aggravating factors, which are factors that make this murder more egregious than other murders. No matter how many aggravating factors are presented to you, no matter how egregious those aggravating factors are, you still have to hold off judgment and listen to mitigating circumstances before you make a decision of what the proper punishment should be. Can you do that?
Yes, sir.
All right. Mitigating factors are those factors that may cause a sentence of life to be the appropriate sentence in this case. There can be quite a few different aspects of mitigation. Can you agree to listen to each and every piece of mitigating evidence before you make a decision as to what the proper punishment should be?
I can.
Okay. This is not the time for us to discuss the details or the facts or the pieces of evidence that relate to each aggravating factor or mitigating circumstance. That's for the trial. So I'm not going to ask you feelings about individual mitigators, but do you think, would your answer be the same, that you would keep an open mind and truly consider the mitigating evidence regardless of what piece of mitigation is presented to you? Let me rephrase, that was a bad question. You agreed you have to keep an open mind and listen to the mitigating evidence. If I stood up here and talked about 100 different potential mitigating factors, would your answer be the same, that you would consider each and every one of those, the evidence that relates to each and every one of those, keep an open mind, and then make a decision?
Yes, sir.
All right. Even if at first blush you hear something that is presented to you as mitigation, and at first blush you may be thinking, well, I don't know if that's important or mitigating in my mind. Can you hold off that judgment until you hear the facts surrounding it?
Yes, sir.
Okay. Do you think that the integrity of the criminal justice system deserves to have jurors keep that open mind and listen to all the evidence before making a decision?
In fairness of everything that we go through as this country and our justice system, absolutely. If I was to be judged for something, I'd want everybody to listen to everything before judging me.
Okay. And once you go through and hear all the evidence, you then begin a weighing process of the evidence. You could determine, you have a few options. If you hear this evidence, you can determine whether or not the evidence has proven the aggravating factors and the mitigating factors, and you could say it has proven it. Or you could say the evidence hasn't proven that factor and I'm going to disregard it. Or you could say the evidence has proven that factor, but I don't really think that factor is important or weighty in my decision, so I'm not going to give it much importance. Or you could say that piece of evidence in my decision-making process as far as what the proper sentence should be is really important, and I'm going to give it a lot of weight. That's up to you. Can you go through that weighing process and that analysis in coming to your conclusion?
Yes, sir.
And once you go through that process, it is that point that you determine in your own mind what the proper punishment in this case should be. And that's an individual decision that you make. Okay?
Yep. Yes, sir.
If you go through that process and you listen to all the evidence and you felt in your heart that life was the proper sentence in this case, could you come back here and say, Judge, I think life is the appropriate sentence in this case, and be comfortable with that decision?
Yes, sir. Absolutely.
Okay. And on the other hand, if you came back and you deliberated and you examined all the evidence and you determined in your heart that the proper punishment in this case was death, could you come in and do that same thing?
Yes, sir.
Is there anything in your life, your background, that makes you think you may not be a good juror for this type of a case? Anything that just jumps out in your mind?
No, sir.
Okay, great. Last area of inquiry, the judge mentioned the insanity defense. And that with that defense comes obviously mental health issues and mental health illness evidence. I'm going to ask a couple personal questions for you and understand why. Either you, a close friend, or a family member, have you, any of those individuals, experienced any kind of mental health issues in your life?
Yeah, absolutely, sir. I suffer from depression.
Okay.
So, and I take a day leave for it to help me along, and yeah, so 100%.
So obviously you think mental health issues are real? Okay.
Trust me, if you knew me when I was on all my medication, you'd think they're real too.
Some people have the opinion that it's not a legitimate issue in society, so. Would you be able to listen to all the evidence before you come to a final decision as far as whether insanity has been proven to you?
Yes, sir.
All right. I think we have one moment, Your Honor. No further questions, sir. Thank you for your time. Thank you, Your Honor.
Hello.
How are you doing, ma'am?
Well, I'm well. How are you?
I'm here.
I'm going to start a little bit where Mr. Buxman left off.
Okay.
Mr. Buxman asked you if you could consider mitigation. And you said, I can, and kind of trickled off, and it sounded to me like you were going to say something else. What was that thing?
Well, so I'm not 100%. What paused me there was the phrase of the question. Yes, 100% I can consider mitigation towards the aggravators. But, you know, it's one of those things I can consider it. I consider both of them. And the weight of each one, I can consider that. And I think that's where I wanted to elaborate a little bit more is, you know, even if a mitigator's there, you know, it might be a small mitigator, but it still may have an impact or a weight towards even a larger aggravator. So that was just it.
Okay.
And I just remember the judge from the first, don't give more than your ass. So that's where I kind of went, let me stop. Yeah, okay. Sorry.
Legal advice, but I'm going to ask you to do the opposite. So if there's anything you think we would want to know or would be helpful information, share it, please.
Right.
And that's exactly correct, right? The state is limited by the law. There's only 16 aggravating factors, and they have to prove the existence of at least one of them beyond a reasonable doubt before Mr. Loyd is even eligible for the death penalty if we get to this penalty phase.
Okay.
Right? Mitigation can be absolutely anything to anyone, and it doesn't have to be unanimous. That is, all of you don't have to agree. So you could say, I found it mitigating just a smile I observed between the defendant and his family member. And for me, that's something I'm going to assign the weight of life to. And the law allows that.
Okay.
Okay, so it's not like a weighing, it is a weighing process, but it's not like a balancing where does the, you know, mitigation have to be more weighty than the aggravation. You just don't have to vote for death under any circumstance.
Okay.
Okay? You also, when Mr. Buxman asked you if the law required it, could you impose a life without the possibility of parole sentence? Do you recall?
Yes, ma'am.
And your answer was, if I believe that was a just verdict.
Yes, ma'am.
Tell me what you mean by that, please.
Well, I'm going to refer to my daughter. I'm sorry, because I try and teach her a lot of life lessons, and all life is precious, okay? We don't kill insects in our household. We catch them and release them. With that being said, mosquitoes are killed without question. Spiders are killed if I can't get them out. And then we also, when we see a dead lizard or an ant, she cries, and we explain the circle of life. So I think all life's precious, and the answer still stands. If it came back and, you know, everything was proven beyond a reasonable doubt, yes, I could come back and say life is a fair sentence. So that's kind of where my weight comes in on that. And it's just a belief that all life is precious. It's not a religious thing. It's just we respect others, we treat others with respect, and we respect all life. So.
Yeah. And I'm not asking you to tell me, like, these are the things that I find aggravating and these are the things I find mitigating. Right. But how do you make a determination about what a just verdict is when you're determining whether somebody lives or dies?
You know, ma'am, to be honest, I don't have a clear, defined answer on that. I would assume that it would be presented to us, and that during the process, I think it would be one of those things that click and say, you know what, I could see where this is a merit of the death penalty, or, you know, I don't see him being guilty because of this. I just think during the process, it'll. I don't want to make a judgment on anything or anyone without hearing everything, and I think that that's where I kind of stand on that.
I got it. When you say everything, what do you mean?
Well, I mean, so let's face it, we've all watched TV shows, right? Whether they hold any truth or not. But we also, I've been in, juror before, so I know that it's got to be proven beyond a certain reasonable doubt. So if during the process it's not proven, then I can't come forward. Just a blatant disrespect for life, I think that would be a death penalty for me. If, let's say it wasn't any of those, but they still committed the crime, then a life sentence. You still took a life if you're proven of that.
Right.
Right? So I think that would kind of merit my decision on the death penalty or not. Once again, I'd like to refer back to raising my daughter as a good human being. All life is equal, and we need to respect life.
When you say, that's what I just don't know what's in your mind. Only you know that. When you say vicious, what do you mean by that?
Let's just say that whoever it is that we are talking about spit on the body after they maybe shot the person down. To me, that would be a vicious, malice, like just disrespectful. And that would be, for me, kind of a lean towards, hey, this is a death penalty because you just had no regard for that other person's life whatsoever.
Okay. And so fair to say this all comes back to your feeling that life is precious.
Correct.
So even if a life is taken showing like a heightened level of disregard?
Correct.
Okay.
Yeah. I mean, that's me.
Yep, I got it. The innocent victim in this scenario, right? So intent, and you talked about vicious and with malice. First-degree murder in Florida is defined as the intentional premeditated killing of an innocent victim.
Okay.
Okay? So let's assume that's true, and now also that the innocent victim is a law enforcement officer.
Okay.
Is death now the automatic penalty?
No, ma'am.
Why not?
I would say there's probably a lot of factors that go into that, which obviously what plays into a death penalty. A blatant disregard for life. No, ma'am. The answer is still no. No,
Okay.
It doesn't make it an automatic death sentence.
If those things are true, the blatant, the disregard for life, the vicious, are you still able to consider mitigation or things that would weigh against that?
Absolutely.
Let me ask you some specific questions. Do you think that if you heard a defendant had been exposed to the effects of racism over the course of his life, would that be compelling to you one way or another?
The effects of what, ma'am?
Racism?
Okay.
Reject the term compelling, Your Honor. It's not the standard.
Can I just answer in just a little bit towards that without?
I sustain that you encourage question.
Okay.
The question is, could you give that meaningful consideration? Okay, and I think you're a thoughtful person. I don't think you're going to sit there with your fingers in your ears and not listen to the information, right? But you know what's in your head. And so some people say, listen, if I'm being honest, I'm not going to meaningfully consider that.
No, I'm going to consider that. And in regards, I grew up in Pine Hills.
Okay.
Okay. So I was actually the minority in my neighborhood, and I was the subject of a lot of racism. It doesn't affect how I carry my life out. I have coworkers that are of other ethnicities, races. It does not affect me unless they are disrespectful towards me. So I understand being the subject of racism. I do. How it affects people is completely different in every individual. Some people let it rule them and destroy their lives, and some people move on. I understand that, and I get that. It wouldn't be a determining factor, I think. If he was the subject of racism his entire life. Once again, like I said, I grew up in Pine Hills. I was a minority there. I was the subject of racism in Pine Hills. My friends have had guns pulled on them, have been attacked. It is what it is. We move on and we live and learn. So everybody handles everything differently. I would have to hear how that all played out. In regards to me, no, I don't think I could let that be a true factor, mitigating factor, but if it was compelling enough, I'm sure I could. Absolutely.
Okay. Since you mentioned it, tell me about the conversation with your coworkers about this case and the case in Texas, please.
Once again, I don't watch the news, and they were talking about the young man, I guess there was 2 high school students maybe that were wrestling. One of them pulled a gun, shot the other kid in the classroom, the teacher's in the background, not breaking the fight up. They were talking about that, and one of my coworkers just said, yeah, Markeith Loyd's going to be going to trial soon. I want to know how that plays out. That was really the extent of that conversation, because I really didn't have time to sit on the front counter and continue conversation. I had the shop to go back into and work, so that was it. But, I had heard something here recently about the Markeith Loyd case, so.
And there wasn't any follow-up either from you or somebody else, like, who's Markeith Loyd? What's he going to trial for?
I knew who he was, so no, I didn't need that aspect. I didn't know what he was going to trial for, and they didn't tell me that it was this one. I didn't even know he had already been to trial over the girlfriend, so I really had no clue.
So when you say you knew who he was, but didn't know what he was going to trial for, I don't understand. What did you know about him or know?
Well, like I said, 4 years ago, I worked right down the road on John Young Parkway at Massey Cadillac.
Yep.
So when this all transpired, our entire neighborhood, the Rosemont neighborhood, there was law enforcement officers everywhere. So, obviously I watched the news to see what was going on at that point in my life. And so I knew about the Markeith Loyd and, the fleeing and just what the news had said, suspected of shooting an officer. That was really it on that part. So, yes, the name stood out, but I haven't followed news.
Well, right. Most people have been exposed to some media attention regarding the case, right? The question is, did you form an opinion about either Mr. Loyd's guilt or what the appropriate penalty should be in this case based on that?
No, ma'am, I did not, because I don't know what truly transpired, okay? Once again, my family is entwined with law enforcement, so I've got my dad who thinks law enforcement's out to get his family. So I don't just take everything at face value when I hear something in regards, because I don't know the circumstance and why and what happened. Once again, I don't know if she was in plain clothes, pulled a gun on him. I don't know that. I didn't watch the news enough to know any of that. I don't know the situation. I don't know the circumstance. For the longest time, I had my concealed weapon permit. I let it lapse. I got rid of all my handguns when my daughter came along, just because I was like, you know what? I don't want to take a chance until she's old enough. So, but I'm going to tell you, if I saw someone draw a gun in public and point it at someone else without identifying themselves as some sort of law enforcement, I would have drawn my own concealed weapon on that person. So I don't know the circumstances. So no, I did not form an opinion.
Okay. And then last question, your conversation with your 5-year-old about this case. I am curious what you were able to communicate or what you guys discussed.
So this is on our car ride home the other day, and she was actually kind of funny about it, because this is where, like I said, she didn't understand. I explained to her that I might be going away for 2 to 3 weeks to go to court over, and I use Markeith Loyd's name because it's my 5-year-old, it's just her and I. I said, he's being accused of doing something, and we have to give him a fair trial. She asked what? I said, taking someone's life. And the entire time she thought that, this is going to be funny, I'm sorry, this is from a 5-year-old. She thought that me and Mr. Markeith Loyd were going to be fighting ourselves. So I had to constantly reassure her, no, sweetie, we're there to make sure that justice is carried out and that he has a fair trial, because that's how our system works, how society, and then we got into a discussion about society and the United States and so on and so forth. So
Teaching moment.
it was a very solid teaching moment. I think at some point, though, I corrected her grammar and she got mad at me. So
Sounds right. Is that when you say you talked to your daughter about justice?
Oh, right. It just the justice system and what's fair and right. Yeah, we had a conversation on that and how we don't judge people until we know everything about what's going on.
Okay. And just want to move topics a little bit.
Okay.
Death, as we've discussed, never required. Not in any case.
Correct.
This case, some other case, the worst imaginable case you can conceive of, it's never required. With me?
Yep.
And that if one juror decides that life should be the verdict, then life will be the verdict.
Correct.
Comfortable with that?
I am, because I kind of understand how this works if we can't unanimously agree on a death sentence, if that was what some of us were going for or some of us were not going for. We can't unanimously agree on that. I understand 100% that it's life without possibility of parole. Yes, ma'am.
Interesting because of your experience as a juror, right? So the first part of this case, where you have to decide if the state has proven Mr. Loyd, guilty beyond a reasonable doubt, or if the defense has proven him not guilty by reason of insanity, right?
Correct.
One of those two things, that has to be unanimous. All 12 of you have to agree.
Right.
In the second part of this, the law asks that each of you make an individual moral assessment about what the appropriate penalty is, okay? There is no such thing as a hung jury. You could have a hung jury in that first part, just like your other experience.
Okay.
But in the second part, that doesn't exist.
Okay.
Right? The law wants all 12 of you to come to your own individual moral assessment. And we talked about mitigation a lot, and it's why any one person would choose life or not choose death. And as we discussed, it doesn't have to be unanimous. It can be unique to each individual juror. You just say, this is the reason I'm not giving the death penalty today.
Okay.
It is your duty, your right, and your responsibility to make sure that your individual moral assessment is heard in this courtroom. It would be a miscarriage of justice, right, if somebody was able to bully or badger another juror into just agreeing with what that juror thought. Would you agree?
Yes.
And you're going to respect somebody's opinion, even if it's different from your own.
100%.
And you'll step in if you see somebody trying to bully or badger someone into changing his or her own individual moral assessment.
100%.
If you have reached a verdict and it's for life and it's not being respected by your fellow jurors, you can say, listen, we're done here if you're not the foreperson. But you can say, listen, we're done, write it down, get the deputy, get the judge, going home. I've reached a verdict. Can you do that?
I can, yes, ma'am. I mean, I would definitely, with my fellow jurors, if someone asked why did I reach my opinion, I would definitely explain that to them. But I wouldn't force my opinion on anybody. I wouldn't allow anybody else to force their opinion on me or someone else. If I felt as if anybody was being bullied, I would definitely intervene. That's just my personality. So,
what I can say this because it's true of me, you're chatty, right? And so some people say, yeah, I have no problem sharing how I've reached this decision. And some people say, I don't know, and I don't want to talk about it. I just know in my heart of hearts or in my gut that this is going to be the verdict. And that's okay too, right? We encourage folks to deliberate. We just don't encourage people to bully or badger each other into changing their own individual moral assessment. Make sense?
Yes, ma'am.
Just one moment, Your Honor. I have nothing further. Thank you. No, ma'am.
All right. So we're going to bring down for a last round of questions, okay? And that is the day that we're going to pick the jury. So, first thing that's going to happen is you're now a purple belt.
No.
I'm sorry, you're a never considered. Okay? If you are present, please.
Okay.
Monday. Eventually, you're going to hear purple dots return on this day at this time. I don't know what that is. It will
Okay.
not be until next week. I have to get enough jurors who are purple dots to get them back here.
Okay.
That day, we're taking the jury and we will also question the so you need to pack that. Pack the suitcase, put it in the car, not take it to the jury. You just have to unpack it, or take it to the jury, one of us out that day. That package will give you includes the slip of phone number call, and just instructions for jurors that are being sequestered, using the thing, but I'm explaining being sequestered a little bit. Any questions?
No, ma'am? Believe it or not, I eat a lot. That's and I get hungry. I get hungry a lot throughout the day. My fiance packs me a sandwich. Okay, perfect. You too. Thank you, ma'am.